It's not good enough to stand in front of you. My Korean is non-existent. But I do know about estate planning. And when I was walking in, Sen said, "You'll be in your crowd. You'll be in with a bunch of geeks." I think that's the word you used. I used to teach IT at the University of Maryland for 5 years. So I know a little bit about what you all do on a daily basis. But I'm here to talk about this, which you probably don't know very much about and don't do on a daily basis for certain. So I'm going to talk about the dirty dozen of estate planning, which is to say the 12 most common mistakes that people make when they're thinking about estate planning. So the 3 basic keys that haven't been used are maintaining control during incapacity, thinking you can do a quick and cheap wealth transfer after death, and protecting your beneficiaries. Those are the 3 things that you must keep in mind that some people didn't do. Some of you might know that man. He's kind of famous, or he used to be anyway. James Dean. He died at the age of 29 by accident, right? And he did intestacy here. That's a big fancy word lawyers like, that says he died without a will. That means that it just went by what the state law says, and for him, he had no wife, he had no children. Instead, he had a father who abandoned him and his mother when James Dean was still a little baby. He hadn't seen his father his entire life, and his father got everything that the man owns. He's currently earning about $7 million a year in his estate. His father is now dead, so his father's wife's son is now getting $7 to $8 million a year because he didn't write a will. Somebody who, the only way he knows James Dean is through some motion pictures. Some people might know her. Marilyn Monroe. She died at the age of 36, also unexpectedly. She did have a will. Some of you might have heard of Lee Strasberg. He used to have a fairly famous television show. He was a very famous acting coach. She left 75% of her money to him. Only she said she wishes he would donate it to charity. She didn't say he must donate to charity. She didn't say he will donate to charity. She said he wishes she would donate it to charity, and he did not wish so. He kept it, and now his wife has her children getting $15 to $17 million a year. Because she didn't draw up the will the way she really wanted it, she only wished that he would do what she wanted. And then the most famous case, probably in American history, Barbara Hutton. She was the founder. Woolworth was a very famous department store, more famous in its day than Nordstrom is today. She died, or her parents died when she was 10. She inherited $25 million. By the time she came to 21, it was worth nearly $50 million. When she died 46 years later, she had $3,000 in her bank account. She had been through 7 husbands. Many of them had been very, very thankful to her because when she got divorced, they got to split half of her money with her. And so she ended up with nothing, and actually 2 of her husbands are still alive and are worth a fair amount of money today. And then there's my favorite. When I was young, John Denver was my favorite singer. He died in a plane crash unexpectedly in 1997. No estate plan. He actually had talked to an estate planning attorney 2 weeks before he got into that airplane and crashed. So he had written down some basic ideas. They were going to meet again in another month. They didn't. he died. $19 million estate in probate. The IRS didn't like the way he valued the money. Went to 6 years, and his estate finally won. But if he had written the estate plan, then the IRS wouldn't have had anything to fight about. And he had a pension in the state of Colorado. And in the state of Colorado, because he didn't give a beneficiary on that pension, the state became the beneficiary. Which means that almost everything in John Denver's estate goes to the good taxpayers of Colorado, and not to his children, and not to his wife, but to the good state of Colorado, because he didn't fill out a simple form to make sure that his children were on that list. So those are the bad things that can happen. There are other bad things. The biggest mistake a lot of people make is fail to address healthcare decisions ahead of time. What do we mean by this? Today, in America, 85% of people die in a hospital or in a nursing home. What does that mean? That means the hospital or nursing home keeps them alive for a long time, and what's happening to you or your money, your estate, while you're incapacitated or are not able to do much? Answer? Well, perhaps some of you have heard of Terry Schiavo, that went all the way to the Supreme Court of the United States because the husband, who was divorcing her but still married to her, and the parents disagreed with what was supposed to happen. Because guilt, because, gee, your spouse says, I think he should be doing this, but I don't know because I didn't write it down ahead of time. Or, potentially, you just didn't say that there was a particular decision maker. So when the hospital goes to you and says, well, you're incapacitated, so who do they go to? Is it a brother? A father? If you put it down in writing, then the decisions will be made the way you want. And because it's in writing, you avoid any of the delays that the hospital is going to have to try and figure out who is making what decisions. And of course, time is money, and in the hospitals, time is a lot more money than most places. So make sure that you make the decisions ahead of time. And of course, where do you go to make those decisions ahead of time? You go to an attorney. Why do you go to an attorney? Because as a couple of those examples we already saw, if you put the wrong words in, then the wrong things can happen. And attorneys, our specialty is making sure that the right words are in the right place so that your wishes will happen instead of somebody else's. And what do we call that you'll be doing with an attorney? It's called an advance directive or an advance healthcare directive. It identifies who your decision makers are, whether it's going to be your wife or your oldest son or your youngest brother or whoever else. End of life directives. What does that mean? That means, hey, I'm so incapacitated, I'm brain dead, the only thing that's keeping me alive is a machine. Do you want that machine to use up all of your wealth, or do you want to die and let the money go to somebody other than the hospital? And then, of course, it also gives clear statements of your intents to your loved ones so that there is no more fighting. If Terry Schiavo had a clear statement instead of partial statements in two different places that seem to be disagreement with each other, then those clear statements would have solved her problem. Next mistake that a lot of people make. They don't have a plan in place. That's the biggest thing that anybody can do, is not to have a plan in place. So if you get stuck there in the hospital, you're kind of conscious, but you may or may not be functioning very well, then what's going to happen? Somebody, your wife, your son, your daughter, somebody is going to say, how do we make this happen? And the answer is, in the state of Washington, you go in and create a conservatorship. And then, well, what happens? How does that happen? They go in and they fill out the form, you go find a legal person to make it happen, and eventually, after you've used a whole bunch of time, after you've used a whole bunch of money, after you've gone through a whole bunch of loops that you didn't have to do, after you've done through all of this while your loved ones are emotionally being tried, you get it on the public record. And then anybody else that might be concerned about it gets to find out about it. It's no longer private for you. And then it may or may not happen the way you really wanted it to, because the person who's putting you into receivership may not be the one you actually wanted to do the job for you. And all they have to do is convince the judge that they're the right person. And the judge is going to try and make the best decision, but if you plan ahead, you're the one making the decision, not the judge. One way to avoid that entirely is you simply set up a trust ahead of time, right? Any individual, you set up your trustee. You set up the person that you trust. Does everybody know what a trust is? Okay. A trust is a legal creation. They've been around in English law for nearly 1,000 years now. They were originally actually invented in France, but that's a different story. And basically, a trust requires three things. Somebody like you who creates the trust, okay? And then there's the person that you trust, that's called the trustee, okay? And then there's the stuff that you're going to trust the trustee with, right? Whether that's your estate, whether that's your property, whether that's your decisions about your life. And then the trustee will, legally, is supposed to follow your instructions. And you can give that trustee as much or as little control as you like for whatever it is that you're actually giving then to their trust. Another option is a durable power of attorney. Now, most of you probably know an attorney is a lawyer, which is true, but there are people who are allowed to be your attorney who are not lawyers. Okay, some of you might have bought something with a real estate agent and you wrote in a piece of paper that says the real estate agent can do X, Y, or Z for me. That was giving a power of attorney to the real estate agent for a particular thing. Okay? So you can do that for a lot of different powers, including delegating who's going to make the financial decisions, the financial transactions in your behalf when you're not able to do so. Okay? So for the last 5 months, the last 5 days, sometimes even the last 5 years, whoever you trust, you write out this durable power of attorney, and they have that, and whatever you say they're allowed to do with whatever resources you have, they are going to be allowed to do. Yes?
Is it every decision you mentioned, like your estate and your health decision and everything is covered with this thing, or?
You can have multiple powers of attorney for different things. Okay? So a couple of months ago, I did an estate plan, and he wanted to make sure that his wife was making his health decisions, but his parents were making his financial decisions because he'd been a business partner with his father. Okay. And then his brother was going to be doing something else. So there was different powers of attorney created for different aspects of his life. Okay.
So in that case, there's like how many trusts is required? Is it one trust with the multiple power of attorney? So.
You can create one document that's going to say, but it's generally better to have a different power of attorney for each person. So you'll write up a power of attorney saying this person has the power of attorney to make my health decisions. And so when he or she needs to go to the hospital to help make those decisions, he just hands over the piece of paper that is the hospital needs to know about, because the hospital doesn't need to know about your financial situation, right?
Is the language used in the draft of the power of attorney very clear cut? I mean, you know, there are circumstances where there's some gray areas where things can cross over. So if you create two separate durable power of attorneys, then there's some gray area that are crossing over. Then how do you resolve, you know, conflicts?
Well, hopefully there's not very many of those gray areas, because that means somebody when they were drafting it, didn't do as good a job as they should have, or they didn't make you aware that you were creating gray areas, because those gray areas are what end up in the courts. And you don't want anything to end up in the courts, because as nice as attorneys are, we're also very expensive. And it would be wiser for you to not have those gray areas, so that the money goes to you, your children or your family, instead of in the attorney's pockets. Did that answer your question?
Sure. Yeah.
Okay. Caution, because power of attorneys, some people, they'll go spend their $17.95 or their $21.95 from LegalZoom or whatever else, and they think, oh good, I've got it done. And you may or may not have it done, because different states have different requirements. And you might accidentally delete some important word in your particular state, or add some word that means something in the courts in your state that you didn't think it was going to mean. So instead of trusting some attorney who put together something to make sure that he makes a buck off you, spend the extra little while and go talk to an attorney to make sure that it's actually done the way you need it to be done in your state for you. Yes.
So I actually worked with a local law firm to get a will in place, and the law firm highly recommended I have a U.S. citizen or a permanent resident for the financial power of attorney and personal rep. So what's the consequence of having a foreigner being a financial power of attorney or like a personal rep? Someone who doesn't have the SSN.
That's a good question.
Let me understand the question. So you're trying to give a power of attorney to a non-resident person?
Yes, like someone in Korea. Like.
Okay.
Legally, it doesn't matter. There's no requirement that the person who holds the power of attorney has to be a U.S. citizen or resident. The only problem with that scenario is the practicality.
That's
Can that person be here when he or she has to exercise that power of attorney? If he's in Korea, that creates a problem.
And the other thing, just putting on my accounting hat there for a little while, is if you're giving them control of your financial resources, then you're also creating some pretty large liabilities that the IRS might become aware of. And although if you can transfer basically as much money as you want to an American citizen with no problem, but if you're transferring it to a foreign citizen, there are legal limits before the IRS starts to step in and say you have to start paying extra money to the IRS for that privilege.
Are there any issues caused by not having an SSN, like when you're proving that I am that person?
There shouldn't be a problem, because the courts almost never use the SSN. But if they're over in Korea, you do have a problem with any kind of financial thing, as well as just, as he said, I mean, if you're injured and you end up in the hospital incapacitated, how is that person in Korea going to know? How is the hospital going to be able to find out and be able to contact that person I mean, it's possible that you have somebody here closer that's going to be doing the contacting or whatever, and in a situation like that, I would probably recommend that you set up some kind of a co-trusteeship or a joint decision-making power so that the person who's actually here has the ability to make the immediate decisions and maybe the long-term decisions, bring in the advice from overseas.
So it looks like clear for citizens, but resident aliens here, but property is in the U.S., also in the outside of the U.S., so not citizens. Then is this the still all those are cover the property outside of U.S.? I mean, not citizens.
Anything that you write up here in the U.S. is instructions to U.S. courts to make particular
U.S.
decisions.
court, okay.
There are agreements between U.S. government / U.S. courts and foreign governments / foreign courts for particular situations, but only for particular countries. The treaty between the U.S. and Korea regarding
Well, your gross
Yeah.
estate
Yeah.
includes any and all properties all over the world.
Right.
So if you own real estate here, then also in Korea, if you die here, then your gross estate has to include the properties in Korea as well. And it will be subject to federal taxation in the U.S. And if you want to also probate those properties in Korea from your name to your heirs, you may have to open up another probate case in Korea just for that purpose. But your gross estate has to include everything.
Yeah, but that paper is effective in here, but actually that is in the Koreans that's under the Korean government. So
So you have to open another probate there,
another probate.
and then probably get a deduction of whatever federal taxes you pay to the U.S. government from the Korean government. If you do a probate in Korea and you pay estate tax to the Korean government, you're going to be able to subtract that estate tax.
Yeah, that's tax.
From the US
but-
government,
Yeah, that's
and
tax.
vice versa.
Yeah, that's tax. But what is the powers? I mean, the papers effective in the for Korean government to.
I can't tell you what the Korean government or the Korean courts will allow. All I can tell you is that they're here in this country, the Korean court rulings or holdings, I'm not sure will hold a lot of value.
So what he's saying is that you need to draw separate papers, one from here and one from Korea, dealing
No,
with each
that's not what I'm
separate.
saying. I'm really not sure how the interplay works here. I do know that if you die here and you have to do your probate, if you have properties here, you have to do your probate, and you have property in Korea. At least in this country, in the U.S., let's just say I have a home in Washington. I also have rental homes in California.
Yeah.
Or Arizona, for instance. Arizona will not honor the probate orders from Washington. So you actually have to open up another probate in the state of Arizona to handle those properties.
Okay.
So you have to have two. And I do believe you have to have one here, one there, but I'm really not sure how each court will honor the other court's rulings.
Okay.
So what if actually, can I actually assign primary and secondary trustees? Let's say if I actually designated my wife as trustee, and then if somehow I and my wife actually just die in the same car accident, so then even if I have this durable powers of attorney, but she's passed away same as I was, then
That's one of the things that if you go to an attorney,
yeah.
the general power of attorney or whatever other power of attorney they're drawing up for you will almost certainly have that. Whereas if you go buy the box of software, it probably won't have that. But yes, different states have different requirements for this, on how you set that, the words required to set that up, but virtually all states do have that capability. So that you can say, this is my general power, but this person has my power of attorney. If this person is incapacitated or unable or unwilling, then it goes to this person, or you can set up, actually, you can do something else you kind of referred to and have a co-power, so that, in fact, it's only given to 2 people, sometimes more than that, but I wouldn't recommend it usually. So that you give it to those 2 people, and neither one of them can act without the agreement of the other on whatever particular thing you're talking about.
Is a will public record?
A will is public record.
So,
Absolutely.
Let's say my whole family died, whatever the accident. So the question is, how do they even know I have a will? How do the people know that I have a will? I wrote a will before I died.
Yes.
I'm actually going to go with that topic
Okay.
in my.
I mean, what if your firm disappears and the whole plane crashes? So.
Yes. He's going to cover that in the
Okay.
probate. And the answer to that is, depending on where you are, there is a different setup.
Okay.
But most places have a way to have that set up, because obviously it's a very important question.
Yeah.
Provisions that are often left out, powers to sell your house. You know, if you're in the hospital incapacitated and all of your money is locked up in that house, and oh, by the way, now you're in the hospital for 4 years now, how are we going to get the money out of that house? Care for pets. I mean, just yesterday, the day before yesterday, I got an email, kind of a boondoggle for attorneys. You can go down into the Caribbean and have a 2-day training session on how you prepare trusts to care for people's pets. 20 years ago, nobody ever thought of that. I mean, the first time I ever worked on any estate, it was because this was a person living in Virginia. They had property in Pennsylvania and Florida, and they needed to have it set up in their will so that their pet was taken care of in all 3 different places. So I researched all the different laws for each one of those different states, so that if that person died with the dog down in Florida, what was going to happen? If they died and they were in Virginia and the dog was in Florida, how was it going to happen, and so on. Okay. Obviously, the power to fund trusts, generally that power is something you want to have created at your incapacity. Sometimes you want it to be created before that power. And of course, the ability to work with the U.S. mail, because believe it or not, the U.S. mail has some pretty strict rules over who's allowed to say, you know, stop sending the mail here or start sending the mail there. And that makes sense. You don't want anybody to be able to do that. But if you walk into the U.S. Postal Service and say, here I have a general power of attorney, it lets me do anything, and they look through there and they don't see the U.S. Postal Service listed, then congratulations, you don't get it done. Okay? Then obviously wealth transfer strategies is something else that a lot of people will make a mistake with. Basically, you want to make sure it's tailored for your assets, not your next door neighbor's assets. Every family situation is unique, especially in the modern American family, and in some cases in your family, right? Because many of you'll have family here, you'll have family in Korea. In my particular case, I have, my father's family is in Canada. We're here, my mother's family is in Mexico, and we have cousins all spread all over the Western United States. So who gets what? We've got 3 different kind of situations there. And then of course, you get married, you get divorced, you have children with one person, you have children with a different person. All of those things need to be set up the way you want it, because otherwise it might not happen the way you want. The answer to that generally is going to be a living trust. Okay. And a living trust, you basically, while you're still alive, you hand over all your assets to this trust. And you are the trustee. Okay? And then, when you pass or you become incapacitated, you just have the trustee become somebody else. What kind of stuff do you put in there? Your business, out-of-state rental properties, right? You've got properties down in Arizona. You have somebody else handle those. And of course, it saves on a lot of probate because, gee, you passed, it's just a new trustee. So you've just avoided that probate. And another thing that it saves on is you're concerned about potentially everybody in the world might know, because it's a legal document, if you put it in your will. If you put it in a trust document, the only people who are going to know that it's in the trust, what it says there, are the people who are involved in the trust and the people who are going to be acting or responding to the trust. Okay? So like Michael Jackson, who died, 7 years ago now? His will was all of like 3 pages long. He had one of the most complex estates ever in the history of the United States, but his will was 3 pages long. Why? Because the will basically said, I have this wife, or this ex-wife, I have these children, and what happens? They all get what is said in my trust documents. And that's basically all it said. Okay? Mistake number 4, failure to understand and plan for death taxes. Now, as of December of 2017, the federal death tax is up to $11 million per person. So that means between you and your spouse, if you have $22 million or above $22 million, then you have to be worried about the federal death tax of 40%. It's relatively easy to avoid. But here in the state of Washington, the estate tax starts at $1 million, 10%. So if you have $1 million property or $1 million estate, congratulations, it's only worth $900,000, and you've got to have some way for your heirs to pay that $100,000.
Is that 1 million? I mean, the sum above 1 million. So if you had $1 million, you'd probably owe 0 taxes. But if you had $2 million, then you'd be paying 10% of that.
It jumps up to 20%, and it actually is.
But it's the amount above the million, right?
Exactly. And what do you have that might add up to more than that? There's a lot of neighborhoods here in this city where if you just have a normal average house, it's going to push you to the point where you actually have to pay estate taxes here in this state. And then your retirement plans are worth something. And then if you didn't set up your life insurance properly, then that's going to be part of your estate. And then there's the extra real estate that you might own for renting. And then you have your investments account. And then you have your autos, your boats. And then there's all that other stuff you've been sticking in your garage or at the back of the house or whatever else. All of those have value. And when we're talking about the estate tax, you have to put a value on every single one of them. And so make sure you plan for that. One of the most basic tools for that, of course, is life insurance. Number 5 mistake, thinking that your children or your minor and adults don't need inheritance protection. It's easy to build inheritance protection for your children. Okay? You don't have them become instantly rich at 18. You set up a trust, and the trust says they get so much money when they're 25, or when they enter college, or when they get to 30, or when they get married, or some other point that you think proves that they are more responsible. Okay? You can't set up the trust that's going to last for their entire life. And then that wonderful wife that they fell in love with when they were 22 years old, who fell in love with their money, or your money, doesn't get their hands on it. Right? And of course, in the state of Washington, you can protect it from creditors there as well. set up a nice spendthrift trust. And creditors, they sue you, the only thing they can get is the annual income from the trust, not the actual principal. And that's about as great a protection as you would ever possibly want. Okay, so you set up a children's trust for the inheritance protection. The adult child becomes a co-trustee. Eventually, you can have them actually become the full trustee. And then, frequently I would say, have multiple co-trustees. So like here, right, you have health, education, maintenance, and support. So anything that your children want to do for their own health, education, maintenance, and support, they have complete capability to do, as long as they leave the principal in place, or whatever rule you decide to make. Okay? These are some of the magic words that estate attorneys know that most other people don't, but those are words that the court will recognize. Okay? And if you don't attach some strings, then obviously, like the Woolworth error, you can make the whole thing disappear. But you can set up some spendthrift protections, right? One of the key things when you're setting up that is to make sure that the income and the principal are distinguished, right? The children can have some of the income when they're 21. They don't get to touch the principal until after they're 45 years old and their wife has passed, or whatever other rule that you want, right? Okay? It protects the children. It protects folk from lawsuits, from bankruptcies, against all those wonderful spendthrifts that they might want to marry or just cohabit with. Okay? You also can, in a will, set up values, right? Traditionally, transfer assets, reduce taxes, reduce your administrative costs. Those are the kinds of things that most attorneys will think of. But you can also set up an ethical will. You can set up an incentive trust. Okay? So they only get so much income unless they finish their bachelor's degree, unless they finish their PhD. You know, if they go on and get their PhD, we'll pay back every dollar that they ever spent on their tuition or their expenses. You can set up whatever incentive you want for them to do whatever goal you want. You can't do that for religion. You know, you can't have it say, you know, when all their children get baptized in X church, because the courts will not recognize that. Okay, but if it's education related, if it's life oriented related, you can absolutely put in an incentive in your trust documents. And of course, you can also have the children involved with the process. A friend of mine, every other year, the family trust flies everybody down to Coronado, California. And they have a family board meeting to decide how the income from the trust is going to be divided up into charities. So everybody gets a guaranteed week-long vacation in Coronado, California, and they also get to think about what the family's money is supposed to be doing for the good of other people. Okay? Another mistake, not preserving your tax deferral benefits on retirement plans. What does that mean? Most of your retirement accounts become immediately taxable on your death. You can prolong the ownership. You can have your IRAs transferred into different kinds of accounts, different kinds of ownerships. Make sure your IRA custodian allows a stretch. Some banks and financial institutions, they're not in it to optimize your estate planning, they're in it to optimize what goes into their pocket. So you want to make sure that whoever you have your IRA with is going to have the capability to do what you want them to do. And of course, you can roll your company plan into an IRA to ensure that stretchability. And of course, if you have the ability, you want to put it into a Roth IRA, because obviously paying taxes right now is much better than paying taxes when the money has grown. You can roll the money into an IRA legacy trust. What that means is all the cash out, you still have the principal growing, and in some cases, you can see it's a massive amount of more than $300,000 in this example, where we started just with $100,000 over the course of a lifetime. Does anybody know how long you're likely to live? If you're under the age of 40 today, the chances are that you're going to live to 120 or close.
Oh, gosh.
That's what just statistics say. Okay? If you're under the age of 40 and you walk into a life insurance company and say, hey, I want to buy life insurance to the age of 120, they don't even bat an eye. Now, if you're over that, or considerably over that like me, then you want to buy it to 120, they're probably not going to do it, or they're going to make you jump through some hoops. But the point is, from the age of 40, all that money sitting there growing can grow to massive amounts. And if you die unexpectedly and that money has to get distributed to your children, even if they put it into a great investment, it's not going to make up for the amount of taxes that they have to pay when you died. If you just plan ahead to put it in an appropriate place, then it just sits there and continues to grow. Okay? It needs to be a revocable trust. You have to get it established now. The beneficiary is going to be, the IRA is that it's going to have to be spring into that when the owner dies, and it's going to be separate from your living trust. That's one of the things that if you're doing one of those software pieces where you just go in and you fill in the forms, you're probably not going to know that you probably want more than one trust. And have I been talking too long?
Yeah, you should probably.
Okay. Sorry. Fail to organize and consolidate. Obviously, you want to make sure you communicate with your loved ones. Make sure you list everything that you have possible. Record everything so that your trustees, your heirs, can find everything when they need to. If you're going into a second marriage, the problems that are there are endless. You thought the marriage was bad, wait till your heirs are trying to deal with it after death. Because you've got the surviving spouse, you've got the previous spouse, you've got any of the children involved with those, and who gets what, when, how. Generally, you're going to set up a completely different kind of trust. We call that a Q-tip trust. And basically what you're going to do is you're going to leave the stuff in trust for your current spouse, and then everything else you're going to leave to whatever version of children you have or whatever other thing that you might want. Okay? They're frequently dividing up the income and the principal, having a co-trustee for the principal maybe, and the current spouse gets complete control of the interest. There's all kinds of things that you can do there to make sure that some of the money or some of your hard work actually goes to your children instead of your current spouse. Okay? Failing to plan for your tangible personal property. A lot of people, when they think of wills, they think of this. They think of a list of personal properties, right? I own this watch. It came from my grandfather. It goes to my son. These are my favorite pair of shoes. They go to my favorite dog. Whatever it is. In Washington, like most states, that is not a will. That will be called a personal property memorandum. So you write a will, and the will says all the stuff that the will is necessary to say, and then it says, for my personal property, I have this personal property memorandum. Go pull it out. I keep it updated on a regular basis. Okay, and then you write down something when you buy it. All right, you just bought a brand new car, so you write the car in there. You'll sign, you'll initial that you put the car on there on this particular date, and you'll write who you want that car to go to. And then when you get rid of that car and you buy the next one, you go in and you edit your personal property memorandum, and you don't need to edit your will. Okay? And then, of course, access to medical records. Just a month ago, my brother called me. He said, Pratt, what's going on? They won't let me look at my son's medical records. And I said, how old is your son? He said, he's 17. I said, that's really weird because in Washington it's 18. And then he told me his wife took their son to the hospital, and because she wanted, my sister-in-law wanted her son to feel like he was involved in whatever the process was, she had the son fill out the paperwork. And the son signed it. And so when my brother went to go make a decision about his son's health, I said, you're not the one who signed this. We can't give you the information that you'd like. So HIPAA is the federal law that restricts doctors from sharing any kind of health information. And it works, even in members of the family. Because medical personnel are very reluctant to break that law because the penalties are pretty stiff, and there are attorneys who make a very nice living going around prosecuting people for it. So make sure that you have HIPAA authorization for whoever it is you want to actually have your medical information. And then, of course, thinking that estate planning is a one-time event, just a bad idea because, you know, when your grandson gets born, or when your wife dies, or when you get that new car, or when you buy that new house, or you sell that old house, or all kinds of major life events, you want to make sure that you go in and change it, because that will that you wrote 10 years ago, if you go back and look at it today, it might very well not reflect what you want to have happen at the end of your life today. Okay? Okay?
Excuse me, there's a question.
Yes.
How often do you recommend to review the will and update?
The answer, I'm sorry, I walked over here away from the camera. The answer to that is at every major life event, and in any event, probably about every 5 years, just to keep up with the law because the laws do change. Okay?
So basically, you should go back to the law firm to get it updated, or should you do it yourself? Like,
I'm a lawyer, so my answer is obviously to go back to the lawyer. But for a major life event, it might be possible for you to say, go in and do it yourself. You know, just add your son's name, you know, your new son's name to the list of other sons, something like that. But unless you're actively following estate law in the state where you live, you probably need to go to an attorney because the attorney is actively following that estate law, so he will be able to look at your particular will and say, the law has changed, so you want to make this change to your will. Okay? Any other questions? Okay?
Okay.
Here.